over the next few minutes, and then we'll pass it off to our final presentation for the day. Um, we have on the agenda wanting to share a couple of different court cases that have come up recently. I will certainly defer a little bit as well to any of the legal folks who may be on the call to chime in or give some different perspective. I'm going to try not to get into any of the specific nuance beyond the cases, but just to share the information with folks. Um, the first one that came up recently is a Court of Appeals decision um, in the matter of the reestablishment of Big Stone County Ditch 21 drainage system records. So this was a case that had gone through the lower courts and made it to the Court of Appeals around reestablishment of records on obviously County Ditch 21 in Big Stone County. In this particular instance, it appears, again, just trying to share what I'm aware of from the opinion. The case revolved primarily around the concept of information that may have been available to the Drainage Authority as a part of their reestablishment proceedings that could have influenced whether or not there was a full need or to go about reestablishment of records in the way that they did. In particular, the case revolved around a system that had historically appeared to have been tile, and some of those records were lost. And as a part of the process, the reestablishment discussed having the system as a open drain system. And so there was some information shared, obviously, through that court proceeding. And then what came up was a number of the communication was revolving around the identification of that system as a tile system came into play and were assumed to have been part of the record or should have been part of the record, according to that court case. So I'm not sure that there's broad applicability to what may or may not happen or how it might affect Drainage Authority proceedings going forward. But again, I encourage you to do some homework if you have reestablishment of records proceedings that may be coming up at some point, just to familiarize yourself with that, or certainly ask legal counsel to bring some familiarity to your decision makers for your Drainage Authority. I will share the names of those this court opinion as well as the other one that I'll talk about here in a moment. I'll type those into the chat box here as we wrap up this session, just so people have it for reference as well. The other opinion that also came out fairly recently, and this one, again, I'll try to avoid getting into too much of the nuance with it, has around another appeals court decision as a MCEA case versus the Renville County Board of Commissioners. This is related to the Limbo Creek project that a number of you may be familiar with in Renville County, a public water body that is partly listed on the public waters inventory, and the upper reaches are not identified on the public waters inventory. The Drainage Authority there had gone forward with an order to do some work on the upper reaches of the system under the premise that it was not on the public waters inventory, and were identified or notified early on in the process by the DNR that it was not a public waters, particularly as identified in the public waters inventory. In that particular case, there was discussion about the need for an environmental assessment worksheet to be done, and that was tied to the debate piece became the upper reaches of the system meeting the definition of a public water versus being mapped on the public waters inventory. I believe that's the key premise of the case. That was turned back, or the Court of Appeals decision is such that it recognizes that the public waters rule is applicable for those features that meet the definition of a public water, not necessarily only those features that are identified in the public waters inventory. I think that one has a lot more potential to have ramifications in the world of drainage related projects going forward. Should that particular case and the outcome of that case stay that way. I'm under the impression, and I'm aware at this point in time, that Renville County has appealed that decision to the state Supreme Court. I don't know, and certainly again, John or Cale, if they're on the call or anyone else familiar with it, I don't believe that there's been any indication at this point, and it may take some time before we find out if the Supreme Court will take up the appeal of that case. Um, but that's one that, again, I would venture to say if the outcome stays as is, may have much more broad applicability to the realm of drainage related projects and public waters permits and regulation as a whole. If it sticks to the fact that if something meets the statutory definition of a public waters versus being explicitly listed on the public waters inventory. Um, so I'm going to pause there for a minute and just see if there are any questions on that, or if any of the, again, legal folks that may be on the call want to chime in and provide a little bit more clarity, or if I did misspeak a little bit. I do see a note in here. John and Cale note the Supreme Court's decision to review is discretionary, and the court has not yet ruled on whether it will review the Court of Appeals decision. So I think that's an important point. Again, the Supreme Court doesn't have to review it simply because the appeal took place. They simply at some point will make a decision first of whether or not they intend to review the appeal. So any questions on those? Again, I will type in the court case names and the headings from the documents that I have. We've discussed these briefly at the drainage work group in terms of just sharing the information, and we've disseminated the appeals decisions, or the opinions, I should say, to membership of the drainage work group. So if you have interest in that, I have access to them and can send them out. Otherwise, you can certainly contact Emily or other representatives who are on the drainage work group or regularly visit the drainage work group, and we can get that information out to you. Hearing nothing else or additional commentary, um, in terms of things that the drainage work group has been working on the past year, there were a couple of items that we talked about that were statutory language introductions from the last legislative session. We talked about both of those at the beginning of the drainage work group season. So our drainage work group typically meets from June to July through December/January. The two bills that were introduced, one was related to reestablishment of records. Another was related to watershed district financing for drainage projects. In both instances, when we brought the discussion to the drainage work group, the determination was made that there wasn't really a significant amount of interest in pursuing any sort of statutory changes from the language that was introduced to the legislature. So neither of those has really progressed through the drainage work group to this point so far this year. Without an entity that really intends to sort of champion that, we try to be careful to not have things be pushed through at this point that there's not a desire from some entity that sees clear improvement in process. Not to say that those bill languages didn't have things that certainly could have made improvements to the drainage code. But again, with the group structured the way the drainage work group is, it's important to have a couple of entities interested in pursuing and pushing for that sort of work to continue within the drainage work group. We've also talked a little bit this year about drainage system road crossings recently. We had some folks from the Township Association come in with some questions around when drainage proceedings lead to road crossings being removed or fixed or adjusted as a result of that proceeding. Who is the entity responsible for payment? So that was a good discussion. I think there's a couple pieces that'll be important in that, and that part of it is simply the definitions. When the road authorities are trying to understand drainage proceedings, they may not understand the difference in the subtlety behind the difference between repairs and improvements and other proceedings. And that certainly makes a difference in who is the responsible entity to pay for it statutorily. I think in a number of those instances, there's flexibility for the drainage authorities to offer some assistance or to not necessarily have it be a clear black and white of who has to pay for it. So we're working on trying to develop sort of a decision matrix for those public road crossings, not talking about private crossings that someone may have on a ditch system or things like that. just to help clarify the instances where it is pretty obvious that there's an entity that should be responsible to pay for repairs, whether it be the road authority or the drainage authority, and also to identify some of those areas where there may be a bit more ambiguity or a bit more flexibility for the drainage authorities to have some of that discretion in the process. With just a couple minutes here, the other topic that I want to just introduce, because I suspect there's a little bit more momentum behind this, is the idea of providing some additional clarity to what it means to be an adequate outlet for a drainage project or proceeding. As most of you are likely aware, for a number of different drainage proceedings, there are assessments that are done as a part of the process to determine that there is an adequate outlet for the drainage project or improvement. When that outlet adequacy is determined, that's a required statutory component of moving forward with some of those projects. The catch is there's not a lot of substantive, very clear, I'd say definition, but characteristics of what it means to have an adequate outlet. So that term being a little bit gray is beneficial in that it provides the drainage authority and provides the engineers that are supporting those drainage projects the ability and wiggle room to help define and craft what it means to have an adequate outlet. And the reason that that's beneficial is there's not necessarily a lot of similarity in some outlets. You need to have some flexibility, or it's helpful to have some flexibility for outlets that are discharging into different types of water features, different types of drainage systems, and things like that, so that you have the flexibility to determine the outlet adequacy relative to the environment that the outlet exists in. So again, what's downstream, what's upstream, what's the substrate, and what are the soils like, and things like that, to help determine whether or not that outlet is adequate. The downfall of that ambiguity in the definition, without sort of those strict criteria of what it is or isn't to be an adequate outlet, is that there appears to be an uptick in the number of challenges coming from environmental groups or the DNR, or just kind of pushing back on some of those proceedings as to whether or not an outlet is indeed adequate. So it's a double-edged sword, right? On one end, you have the ability to be a little bit more adaptable to what's in the landscape. And on the other side of that sword, you might have entities who push back a little bit more frequently and challenge the concept of what it is that you've defined as being that adequate outlet, and whether or not it is indeed really, truly, quote unquote, adequate. So I think there's a little bit of repeatability and dependability that's important from a drainage authority's perspective, to know that when a determination is made that the outlet is indeed adequate through the process and through the engineer's review, that you're fairly confident that if challenged on it, you're going to have the resources, you're going to have the technical background and information to support that decision in a way that's clear and articulate, not only to the drainage authority, but to other interested parties, be it downstream landowners, and again, some of those other entities that may be in play. It's just something worth thinking about. There seems to be, as I mentioned, a fair amount more momentum behind that topic right now, in part because we've seen a couple of drainage authorities that are getting some pushback as to whether or not the outlets that they have determined to be adequate indeed sort of meet that intent or purpose behind the concept of adequate outlet. So with that, I will just ask if there are any questions briefly, and then we'll go ahead and turn it over to our afternoon presenters, which is Chad Engel again and Henry Van Offlen on multi-purpose drainage management. So any questions or comments on that little brief overview on what's going on in the drainage work group or those cases? And again, I'll type that court information into the chat box. All right.